Can I expedite patent prosecution?
So you can't pay an expedite fee. That's not a thing. You can't do it. But there are some things you can do. The first page being a petition to make special. If you're over 65 years of age, we literally have you sign a petition that I file with the application, and your patent application will be reviewed in 2 to 3 months. It's a fabulous opportunity, but you understand the reasoning. The reasoning is if there's an older inventor, we want to, the government's saying we want to give them a chance. Now, I don't think 65 is old, but that's the age they put at it. And the other, which is an inventor's health, which I hope none of you fall into that category. But similar to the age, if the applicant has some health state that could potentially maybe shorten their life, then we can again do a petition to make special. I actually haven't done that one. I've done the age one quite a few times, but not the health. On March 8th, a new pilot program was launched, and it's called a first-time filer expedited examination pilot program. Now, what the Patent Office has said is they looked at the economic environment and they found that startups and people trying to break into an industry, new inventors, were really harmed by having to wait 2 to 5 years. They didn't mention in their summaries, situations like you guys have, but that was the purpose behind it. So this is the first time ever that they've introduced a pilot like this. They're going to accept petitions. Now, usually I will caveat most USPTO pilots, if they're doing pretty good, they'll get renewed each year. But right now, they are saying for this pilot program, they're accepting petitions for 1 year or the first 1,000 applicants. This is only, remember we talked about provisionals, it doesn't work. We talked about designs, it's not applicable. This is solely for first-time filers, and I have a second page, so I'll show you what you have to do. It's solely for first-time filers filing a very first non-provisional patent application, so a utility application. So in order to be eligible, and of course there's a form, it has to be your very first patent. So if you worked at a company and you're the named inventor, you don't own the patents, but you're the named inventor on another patent or 5, you don't qualify. But if you've never had a patent before, if you've never been named on a patent anywhere before, actually a patent application, even if it hasn't granted, that's the first hurdle. The second hurdle is you have to be considered, remember I talked about the tiers, a micro entity. Remember how I said there's micro entity, small business, and regular filing. And so I looked it up so you would know. Currently, the definition of micro entity is that any inventor must have had a gross income in the past calendar year less than $212,352. So that's pretty specific. So they're targeting first-time inventors in what they consider the micro entity financial bracket. They're not opening this up to first-time inventors working at Microsoft or Apple. They're focusing this on startups, new businesses, or individual entrepreneurs. And then the last thing you need, which I would jokingly say I've just given you, but actually the USPTO has videos you can watch, is you have to attest that you've been trained in patents. So they really thought this out. They want the first-time inventors that can't afford the investment yet, potentially, i.e. micro entity, and they've been trained in patents. And if you meet those qualifications, they're going to treat this just the way they're treating the petitions to make special, and your application will be looked at in an expedited fashion.